Hey YouTube family, it's Humberto from GrayLaw TV, and today I'm wearing my mask in support of all of you that are going through this hard time, COVID-19, but today I'm going to talk about some good news. There is some good news that's coming from USCIS, and I'd like to share that with you because it's a tough time, right? Now we're in a tough time, and it seems that it's doom and gloom. I want to give you guys some good news, and hopefully it'll make your day. So when you file an adjustment of status, it could be either employment-based or family-based. It's when you're waiting for the actual green card interview here in the United States. Well, immigration, and again, this is stuff you can't get on the internet. This is just from my experience as an immigration attorney for many, many years and going through this stuff. So, generally from the date of filing the adjustment application to the interview, takes about a year. Now, maybe 4 or 5 years ago, immigration waived all employment-based interviews. If you had an employment-based case through one of the 5 employment-based categories, your interview was waived. You just received your green card in the mail. It usually took maybe about 6 months or so. Well, recently what I found is they are actually, again, waiving green card interviews for employment-based cases. Why are they doing that? I would imagine because there's just such a backlog right now, and so there's going to be a need once USCIS opens back up to expedite these things, adjudicate them, and get them through. I have heard from other AILA members, that's the American Immigration Lawyers Association, that they've received also some family-based petitions that have waived the final interview. So this is good news, folks. If that's happening, that's great. Immigration is giving us something that they normally don't do. They are requiring, again, recently they're requiring that every case be interviewed. Hopefully this trend will continue. They'll continue to waive these interviews, and you'll get a green card in the mail. Let's talk a little bit about. We've seen also labor certification. So labor certification is an employment-based application that is filed prior to filing the adjustment of status. It is for a green card, and it's filed through an employer. What I'm understanding is that they are expediting these labor certifications as well because there are not so many recently being filed, and we're seeing times cut substantially in half. So if you have an employer that's willing to offer you a job position in the future and they're willing to file for labor certification for you, it may be a good time to do that. Could be fast processing, and I think that would definitely benefit you. So, if you have an opportunity to file a labor certification, it's either through the second-based employment category or the third-based employment category. I think it's a good time to do that. Immigration usually issues what's called requests for evidence in connection with certain applications, non-immigrant applications. They issue what's called NOIDs, Notice of Intent to Deny, on some family-based cases. There's always a time frame in which you need to respond to the request for evidence or to the NOID. Immigration has announced they're going to extend that period. So if you have an RFE or NOID that was issued between March 1st and May 1st, you're eligible for a 60-day automatic extension from the due date. Okay, so if you have one of those applications and for whatever reason, your employer, let's say, is not at the workplace at this point because of COVID-19, and they can't get you the information that you need to respond to this, or you can't travel, you're in shelter in place, you're at home, and you can't address these certain things, well, there's going to be an automatic extension of time. This is great, so you'll be able to have more time to respond to these notices, and it's going to benefit a lot of immigrants during this time. If you have a visa that's expiring, typically this is going to be the ESTA, where you have 90 days There's no extension. There's no change of status on these things. I mean, it is for a long time the 90-day ESTA visa waiver program. You cannot overstay, or you will lose the privilege of being on that ESTA. Well, due to COVID, you can actually ask for what's called satisfactory departure from the U.S., okay? And you can do that. I'm going to put a link in the description below. You can do this by email. You're going to notify CBP, Deferred Inspection, CBP, Customs Border Protection. They're the ones that are authorized to issue these satisfactory departures. Automatic 30 days, and it can be extended twice, so up to 60 days at this point. So if you can't get a flight back home, folks, you have an option. You can get a current extension. These are good things that are happening out of this COVID-19. So I'm going to put the link below where you can email Deferred Inspection. You have your passport data page. You have your I-94. That's the form, the green form that they give you when you come into the U.S. And proof, of a flight itinerary that's after the expiration date of your I-94, your ESTA, and you will get what's called satisfactory departure. Then in the system, it will show that you've maintained your status even though it has expired. Okay? Really important. So you're able to do this. It's great. Also, let's say you have a non-immigrant visa that's about to expire and you've had some problems because of COVID-19. You can also ask for a B1, B2 extension. You file that on I-539 to immigration. Again, document what's going on. Document your status, the reason you can't travel. Perhaps your H1 has just expired or your F1 visa just expired and you can't depart. What you want to do is make sure that you have filed this I-539. You can request up to 6 months, okay, to be here. You can cite COVID-19. Everyone knows what's going on. It's public knowledge. So you can do that as well, which is wonderful. What about unemployment benefits? Everyone's asking questions. They're calling me, Humberto, can I get unemployment? The answer is yes. You can file for unemployment. It's not going to affect you on the public charge end because the employer is the one that pays in. Okay? Now, I've had a lot of questions with regard to undocumented aliens. Do they qualify for unemployment? No, they do not. However, and this is really important, folks, both citizens of the U.S., permanent residents of the U.S., and undocumented individuals qualify for certain state benefits, okay? It's called state disability, sick leave, or workman's compensation. You should look up this stuff. Ask your employer about this stuff. This is very important. You can qualify. So let's say, for example, I have one client who owns a nursing home, and they have employees who were affected by COVID-19. They got sick. So the question was, and one was an undocumented worker. I didn't know this, but it was an undocumented worker. Most were in status and legal. They all qualified under California state disability. They got sick, they filed for state disability, and they received checks. They're receiving money from the state. Sick leave, if they have family members who were sick because of COVID-19 and they have to care for them, or children that couldn't go to school, they can apply under state rules for state sick leave, okay? And they receive money. It's very important. Third, workman's comp. There's certain workman comp cases that can be filed in the state because you're injured. So you may qualify for workman's comp as well and receive substantial money. So these are benefits that both legal and undocumented individuals can take advantage of. You should look into your state rules with regard to these benefits and see if you qualify. It doesn't hurt. You've probably heard, so some of my clients have corporate entities. You have the Paycheck Protection Program, and you have currently, it's called Main Street Loans. Okay, one is issued by the SBA, the other is issued by the Federal Reserve. These are loans that are very low interest rate. Actually, the PPP, the Paycheck Protection Program, is a forgivable loan. So you don't have to pay it back as long as you spend the money on payroll and certain expenses in your business. You would qualify. The way that you qualify is you look at the number of employees you have and you have that payroll amount, okay? That payroll amount times 2.5 is the amount you can request on that loan. The loan is issued and you must pay 70% of the proceeds of that loan to your workers. 30% can be paid on expenses such as rent, utilities, etc. It's a wonderful program, but it's first come, first served. They already ran out of money on the first tranche, so there's another tranche that's coming in, $250 billion. So if you're in the process, work with your bank, continue to provide the information, and get that loan. Okay, it's going to be wonderful. The Main Street loan is a brand new loan that's just come out from the Federal Reserve. So you want to stay up to date on that. You can Google Main Street loan, Federal Reserve. It will come up. That's going to be, issued through the bank as well. So contact your bank, see if they're participating in that particular loan service. This is going to be an interest loan, probably very low, 2-3% loan. It's going to be deferred on principal and interest payments for the first year, and it's payable over a 4-year period. So this could be a good benefit to keep your business going. If you have a business, again, it doesn't matter if you're a non-immigrant or immigrant, etc. If you have a business, if you have a company, and you have payroll, you have employees, you're going to look into this, okay? All right, GrayLaw family, we're with you. Please click below, like and subscribe. Just trying to get you information, current, up to date, and keep you up to speed with what's going on.